Hello, everyone. Welcome to the eRenew webinar series on Europe and the world. I'm Carrie Otterburn of the Leuven Center for Global Governance Studies, and I will be your host and moderator. Today, we are joined by Professor Rebecca Perlman, who will discuss her new book, Regulating Risk: How Private Information Shapes Global Safety Standards, which was published last year by Cambridge University Press. Professor Dr. Rebecca Perlman is an assistant professor in the Department of Political Science at the University of California, Berkeley. Her primary field of research is international political economy, and she focuses on regulatory politics, the governance of multinational firms, and the politics of climate change. Also joining us today as expert discussant is Professor Graeme Auld. Graeme is a professor at the School of Public Policy and Administration at Carleton University. His research focuses on comparative environmental politics and policy, global environmental governance, and the rise of private governance and authority. We will begin today's webinar with a presentation by Rebecca of approximately 30 minutes, and then we'll turn to Graeme to kick off the discussion by offering some reflections, asking a few questions, and Rebecca will have an opportunity to respond. And then we will turn to questions from you, the audience. So please feel free to send your questions for the speakers at any point during the webinar using the webinar Q&A function. You can find this at the bottom of the Zoom window. I will collect your questions to share with the speakers during the audience Q&A following the presentations. Before we begin, just a few quick words about the eRenew project. The EU Research and Education Network on Europe and the World, or eRenew as we refer to it, is an Erasmus Jean Monnet network bringing together 19 higher education institutions from Europe, Asia, Africa, and the Americas, with the goal of improving knowledge and enhancing debate on the EU's role in an ever-changing world. On behalf of eRenew, I would like to thank both Rebecca and Graeme for joining us today. And now, without further ado, it's my great pleasure to pass the floor to Rebecca. You have the floor.
Great. Thank you very much. So let me share my screen here. All right. Can we see that? Oh, okay, great. Well, thank you for the opportunity to talk a bit about my book. Let me just jump right in. So we all want to be able to enjoy an apple without having to worry about whether that apple is going to poison us. Regulations can play a key role in ensuring that the apples that we all like to eat, whether they're grown domestically or imported from abroad, are in fact safe. The problem is that regulations can also act as a trade barrier, with some governments using claims of protecting health and safety as an excuse in order to protect domestic producers. As it turns out, accusations of this sort of behavior are rampant in WTO forums. So just to take one example from the book, in 2007, Argentina filed a specific trade concern in which it accused several of its trade partners of unfairly blocking crops that had been produced using more affordable pesticides, with the implication being that the same standards were not being applied to crops grown using more expensive pesticides. Argentina argued in its trade concern that this was unfairly harming developing countries which couldn't afford the more expensive pesticides. And they said that these rules weren't justified by science. A number of countries actually echoed Argentina's concern, with some going so far as to suggest that this represented a deliberate form of protectionism put on by developed countries. So was this actually deliberate protectionism? How would we know? This highlights what has become a major problem for the WTO. On the one hand, it is critical that countries be able to protect their populations from harm. At the same time, regulations that impede trade for reasons orthogonal to health and safety can have significant economic consequences. So the way that the WTO has tried to address this is through a two-pronged strategy. First, the WTO encourages countries to base their national regulations on international standards. Second, where countries put in place regulations that are stricter than the international standards, the WTO requires that countries be able to show upon challenge that those regulations are based on science. So essentially, my book asks whether this dual reliance on international standards and science can actually be effective in preventing unnecessary regulatory barriers to trade. More generally, I'm interested in understanding what drives regulatory barriers to trade in the first place, such as the types of barriers about which Argentina complained in 2007. So my argument in brief is that an often underappreciated source of these regulatory barriers is the ability of private actors to exploit information asymmetries about the risks of their products in order to acquire preferential regulations that then act as trade barriers. I demonstrate in the book that these same information asymmetries that exist at the domestic level are actually replicated at the international standard setting level. So this not only complicates any sort of objective evaluation of what is or is not a scientific standard, but it also means that international standards, rather than solving the problem, may end up perpetuating these biased regulations. So before getting into that argument in a bit more depth, I want to very quickly just talk about what the existing literature has to say about where regulatory barriers come from, and also whether or not international standards can help. So essentially, there are two main explanations in the literature for why we see regulatory barriers in the first place, and they're not mutually exclusive. The first is that regulatory barriers result from diverging national preferences. And the second is that regulatory barriers are sort of deliberate attempts by governments to privilege certain domestic actors. To the extent that regulatory barriers result from the second explanation, a number of scholars have suggested that international standards can help. The reason that they think that this is the case, well, there's several reasons. One is that international standards are one step removed from the domestic political process. They bring together a wider array of national actors, which theoretically might diminish the influence of any given domestic interest. And they're also set in many cases by theoretically apolitical technocrats. There's also this big literature suggesting that international cooperation can help governments avoid catering to special interests at the expense of the public good. So this too theoretically should help international standards be less biased. Now, this is not to say that everyone has agreed that international standards are less biased or less likely to cater to powerful actors. But even among those who think that these standards may still exhibit signs of bias, the focus has been on sort of traditional forms of capture for the most part. So what I suggest is missing from these existing explanations, both for regulatory barriers and for the potential benefits of international standards, is an appreciation of where the information that undergirds both the domestic regulations and the international standards actually comes from, and how this itself could create types of bias and barriers. So as it turns out, as I focus on in the book, a lot of the information that undergirds these regulations, particularly when it comes to the regulation of risk, comes from those very actors that are being regulated. The reason is that producers of potentially dangerous products know far more about the risks of their products than do regulators. The reason is that producers are constantly running internal studies. They're the first to receive consumer complaints. They observe worker exposures. All of these things means that producers are usually the first to know when there is a problem with their product. At the same time, domestic regulators typically lack the resources to study all of the products on the market. The same is true with international standard setters as well, which actually face even larger resource constraints in many cases than domestic producers. So what this means, as I talk about at length in the book, in the theory section, is that both domestic regulators and international standard setters heavily and to a surprising degree depend on firms for the information that is necessary to both set and update the regulatory rules. As it turns out, this can create some major problems. So even though firms may be the first ones to learn about the risks of their products, they're not always the first ones to want to reveal those risks for obvious reasons. Moreover, the harder it is for regulators and other third parties to identify the risks from firms' products independently, the more incentives that firms may have to hide those risks or avoid learning about them in order to skirt legal liability laws. This can lead to dangerous goods remaining on the market long after firms have uncovered those products' risks. Now, governments aren't stupid. Governments recognize that this can be a problem. And so the way that some governments have dealt with this, especially for particularly problematic sectors, is by instituting a special type of regulatory rule. Under these regulatory rules or regulatory institutions, the governments require that products be reevaluated for safety on a predetermined basis. During these reevaluations, producers are asked to provide the relevant information, proving that their products are safe by modern scientific standards. Should producers fail to provide the required information, this is treated as equivalent to evidence of harm, and a stricter standard or an all-out ban on the product is imposed automatically. So effectively, this is a precautionary standard applied retroactively to existing products. And for this reason, you'll often hear me refer to this as retroactive precaution or retroactive precautionary institutions. It turns out there are actually a lot of examples of this, and here are just a few examples of these sorts of institutions that have played out in different countries. So this retroactive precaution might seem like an innovative and helpful solution to this information asymmetry problem. And yet, as I argue in the book, it can actually end up putting more power into the hands of those firms that hold the information about their products. And this can help them acquire regulations that then act as trade barriers. In order to understand why that happens, we need a theory of firms' preferences. So in the book, I lay out this theory of firms' preferences that begins with a kind of standard assumption, which is that firms seek to maximize profits. That should be pretty uncontroversial. As might make sense, firms can benefit in terms of maximizing their profits from regulations that are lenient on their most profitable products. So it allows them to sell more of those products. What is perhaps less intuitive is that these same firms may also benefit from stricter regulations on their less profitable products. Why would that be the case? So you can imagine a firm that produces two products that are substitutes for one another. One of those products is a high profit product on which the firm holds a monopoly, like a patent. And the other is a lower profit product that is competitively produced by many firms. Under certain market conditions, the firm can maximize its profits by shifting consumers away from that competitively produced good and towards its high profit product on which it holds a monopoly. One way that firms can do this is by regulations declaring the less profitable product unsafe. So what might that look like in practice? Well, it turns out a really great example of this is OxyContin. So OxyContin, as many of you probably know, is a very controversial now opiate painkiller that's produced by Purdue Pharma. What you might not know is that in 2013, the original patent for OxyContin was set to expire. At the same time, Purdue Pharma had been working on producing this, quotes, harder to abuse substitute for OxyContin. And on the very same day that the patent for OxyContin was set to expire in 2013, Purdue convinced the FDA to ban the original formulation of OxyContin, thereby preventing any generic producers that had all been lined up ready to produce this generic version of OxyContin from producing it. As a result, Purdue Pharma then got to sell its new version of OxyContin without any market competition. That was great for Purdue, but you can imagine that under a lot of circumstances, it might be harder to convince the regulator that the older product is in fact unsafe, especially when there is no evidence that it is unsafe. Where retroactive precaution gets really useful. As I mentioned, under retroactive precaution, a lack of information is treated as equivalent to harm, leading to stricter standards automatically. This means that rather than having to lobby for stricter standards on out-of-patent products, firms can simply withhold information when they have a substitute, and they will get those stricter standards automatically. One thing that I'll talk a little bit more about later in the talk and that I lay out in more detail in the book is that generic producers and other interested third parties are often unable to compensate by providing the relevant information needed to keep these products on the market, making this a very effective strategy. So this leads to my first hypothesis that I test in the book, and that is when retroactive precaution exists, we will see regulations becoming stricter on less profitable products for reasons that are partially orthogonal to health and safety. Second, if my theory of firms' preferences are correct, this means that we should also see companies actively lobbying for stricter standards on their lower profit products if it allows them to sell more of a higher profit alternative. Finally, to the extent that retroactive precautionary institutions can help firms acquire these preferential stricter standards on their less profitable products, we should see innovative producers supporting these retroactive precautionary institutions which in turn might help explain why we see them instituted in the first place. So what I want to talk about today in terms of testing these three hypotheses is a case that is really central to the book. And that is the case of the regulation in the United States and at the international standard setting level of pesticides. Why is this a good case? Well, it's the earliest example of these precautionary institutions being implemented. So enough time has passed to really see the consequences of these institutions. It turns out these rules have really major implications for agricultural trade, which itself represents 10% of total merchandise trade. So these rules are really important for global trade. This is also a case in which international standards exist and they're extremely important. And finally, it's just an incredibly rich source of data, which makes it possible to test these hypotheses in a more systematic fashion. So a quick crash course on how pesticides are regulated, since this is necessary in background information. So pesticides are subject to what are known as tolerance levels. Tolerance levels are the maximum amount of pesticide residue that is permitted to remain on an agricultural commodity at the point of market entry. So essentially, it's the pesticide on your apple. These are set on a pesticide by commodity basis, and they apply to both domestic and imported goods. In the United States, where I'm focusing my research, the regulator is the Environmental Protection Agency, whereas at the international level, the regulator is the Codex Alimentarius Commission. So the Codex Commission has legal authority through the WTO, meaning that it is the relevant international standard setter in this space. Its tolerance levels are overwhelmingly set by independent scientists. So according to conventional theories of capture, Codex actually should be fairly well insulated from catering to these private actors. However, according to my theory, Codex should still exhibit a fair bit of bias. And that is because both the EPA and Codex have both implemented a retroactive precautionary institution. Under these institutions, tolerances are reevaluated approximately every 15 years. And it is companies that are required to provide the necessary data for these reevaluations. As with all of these institutions, a failure by the companies to show that their chemicals are safe leads automatically to a stricter standard, or in this case, an outright ban of the pesticide or that tolerance. So as a reminder, my first prediction is under these institutions, we should see that regulations are getting stricter over time on these less profitable products. So in order to test that, I collected data on US and Codex tolerance levels. I looked at how they had changed across a 20-year period between 1996 and 2015. I focused only on pesticides that were regulated both in the United States and at the international level in order to ensure comparability across the data sets, and also that I was only focused on major pesticides and not ones that would be removed simply due to their lack of use. My US sample contained approximately 3,700 of these tolerance levels, while my Codex sample contained around 1,400. So this is what the data collection process actually looked like. This is just a snapshot of the US Federal Register. Unfortunately, I was doing this before ChatGPT really came into force, so I had to do this all by hand. So this is really just to show this was a huge lift in terms of collecting all of this data. All right, so it turns out these standards are changing quite a lot. You might think they're pretty stagnant. They are not. This is just showing that across both data sets. I just want to draw your attention to this one category of change, tolerances that are revoked. So when a tolerance is revoked, it basically means there is a zero tolerance for the pesticide on this particular crop. So it means you basically can't use it at all. So that's the strictest possible outcome that you get. Now, of course, I also needed some sort of proxy for pesticide profitability. Unfortunately, you cannot directly get a measure of how profitable pesticides are for a firm. But you can get a very good proxy for that. And the proxy is how long the pesticide has been registered in the United States. And the reason that that's an incredibly good proxy for profitability is because when a pesticide is first registered, it's under patent. That patent lasts for 20 years. However, firms will often try and file supplementary patents, which can extend that exclusive use period for a number of years. However, eventually those patents expire and generics enter the market, which then usually reduces the profits on that product quite precipitously. At the same time, the probability of the firm coming up with a substitute product is going to increase substantially over time. So basically, this measure is both capturing whether or not a firm has exclusive production rights of the product and the odds that they have come in with a substitute product. Of course, this proxy is imperfect. You might be worried that it's going to also correspond to all sorts of risks of the products, like its toxicity, environmental risk, etc. So in all of my analyses, I take great steps to try and ensure that these other characteristics of the pesticide are not driving the results that we see. And I'm happy to talk more about how I do that in the Q&A. So basically, here's just the first set of results. So the key variable here is how long this product has been registered on the market. And we see that even after controlling for all of these characteristics of the pesticide that we might expect to lead to that product getting a stricter standard, and this is an ordered logit model where the highest number is the strictest standard, the pesticide, the tolerance being revoked, you see that still the amount of time that this pesticide has been on the market is a strong driver of the odds that this tolerance will become stricter. And it turns out that this is not just statistically significant, it's also substantively extremely significant. The same is true under Codex. So again, even after controlling for all these characteristics of the product that should be driving potential stringency, you see that the profitability of the product as proxied for by the pesticide, the amount of time the pesticide has been on the market, is an extremely strong driver of the odds that these standards become stricter. I did a number of robustness checks in the book, which I encourage you to look at, trying to ensure that this isn't just because these older pesticides are more dangerous. So besides just controlling for this in various ways, and also it's not just because they're less effective, which is another thing that can happen as pesticides get older. And it does not look like those are the explanations for why this is happening. So basically what I've just shown you is that these results are consistent, at least, with us seeing stricter standards occurring on these less profitable products. But that has not proven that this is actually in the interest of these innovative firms. So as a reminder, pause for a second, I'm getting ahead of myself. So you might be wondering if this is actually driven by a lack of information. So I said this is about a lack of information. How do we know that's what's driving this? One reason we know that this is what's driving these results is because the Federal Register actually lists why we see revocations. And again, you see it saying, this is because the firms aren't providing information to keep these tolerances as they were. So we know that that's a big part of what's driving it. I also know from a lot of my qualitative work, and I present this evidence in the book, that this lack of information is about profits. So this is this comes from an interview that I did with a senior executive at Bayer, who told me quite bluntly, once a pesticide goes out of patent, it's really not profitable to continue to pay for the research. So here's someone explicitly saying the reason we're not providing this information has to do with profits. I also mentioned that generic producers often have a hard time stepping into this informational gap. So here's just one quote from the book that kind of attests to this, with one of the people I interviewed noting that there was no incentive for any one company to come and pay for the maintenance of these older generic products, because everyone that produces these products benefits from that information. So there's a free riding problem. So that's part of the reason why you see these generic producers not coming into the gap here. You see the same thing going on at Codex, where it's really a lack of information that is driving this. So this is a quote from one of the annual reports from Codex, where it was said that the main reason for the withdrawal of these tolerances in Codex comes from the revocation of active ingredients as a result of the non-support by the manufacturer. And also it was noted that developing countries don't have the resources to provide this information to keep these active ingredients on the market when a manufacturer, due to market reasons, chooses not to support the product. So again, you're seeing this sort of theme of other actors that want to keep these products on the market don't have the resources or the ability to do so. But of course, as I was trying to say earlier when I got ahead of myself, this only shows that the results are consistent with the theory, but it doesn't show that firms are actually benefiting from this. So to know that firms are benefiting from this, we want to see that they're actively lobbying for stricter standards on their less profitable products. And as I show, they definitely are doing this. So before showing you the more systematic test of this, I just want to show you a very quick case study, which is the case of rosfin metolachlor, which is a pesticide that was first patented in 1973. So the patent for this pesticide ran out in 1993. And a few years later, Syngenta, the producer of this product, comes up with this substitute product, S-metolachlor, which, as the name suggests, was very, very similar. but it had a patent. So at the same time they come up with this new product, they cancel their registration for the old product. But that doesn't stop generic producers from continuing to sell the old product. And Syngenta doesn't like that. So in 2002, they sue the EPA to get that old product banned. And in the course of that suit, they say that a failure to ban racemic metolachlor would be a clear statement to the public and the agrochemical industry that EPA no longer values the environmental benefits associated with reduced risk products. That is a pretty hypocritical statement coming from a firm that has very happily sold that product right up until they came out with a substitute. So that's just one-off example that firms are actively doing this, but that's not very systematic. So you might want to know, are they doing this more systematically? To test that, I collected petitions by firms requesting changes to existing tolerance levels in the United States. This is, again, just to highlight that this is all done manually. And this is just an example of one of those petitions that I was collecting to see what these firms were up to. So I collected all petitions that firms had submitted in the United States between 1999 and 2015, requesting a change to an existing tolerance level. This accounted for around 900 requests. And almost exclusively, these petitions came from one of two types of actors: innovative firms and a farm lobby group known as IR4. So this was actually really helpful to have this farm lobby group because it allows me to separate out the two types of petitions and see how these two actors are behaving. If farmers are lobbying for stricter standards on less profitable products, it suggests that it's actually something to do with their safety profile. If it's just the innovative firms that are doing this and the farmers aren't, then it suggests that it's probably more to do with profits, because farmers should have a very strong interest in ensuring that their products are in fact safe. So the outcome that I'm looking at here is a dichotomous outcome. I'm using a logit model where the outcome is coded as 1 if the request was for a stricter standard, and a 0 if the request was for a less strict standard. The explanatory variable I have is the amount of time this product has been registered at the time that the petition was submitted. Interestingly, both farmers and innovative firms are lobbying for stricter standards around 15% of the time. However, where these actors look very different is when it comes to the types of when they are lobbying for stricter standards. So whereas companies are far more likely to ask for a stricter standard if the product has been registered for a long time, and especially after that kind of 20-year cutoff when the patent expires, this is not true when it comes to farmers, which are no more likely to lobby for stricter standards on these older products that are out of patent than they are to lobby for stricter standards on the newer products. So that suggested that this is something more systematic. But even if you don't believe those regression results, you can believe the producers that actually will admit that they do this. So in an interview with a senior executive at BASF, I was specifically told it's all about profits. Companies are constantly trying to phase out old products in favor of newer ones. So these companies are pretty upfront that this is exactly what's going on. Finally, in just the last couple of minutes that I have, I want to talk about this third prediction that I put forward, which is that if companies actually benefit from this, and if the retroactive precautionary institutions allow them to get these outcomes more systematically, these companies should also support these institutions in the first place. And we see that in the United States. So these retroactive precautionary institutions, these reevaluations of tolerances, were first put into law in 1972 in the wake of Silent Spring, so from a lot of public pressure. However, by the mid-1980s, these reevaluations were totally stalled due to a lack of resources to support the system. So what happens? The innovative companies could have sat on their hands and done nothing, but instead they actually sat down one summer with the environmentalists and they came up with this proposal in which they themselves would fund the reevaluation process to get it back on track. So they're giving money to this effort to get these reevaluations done. Notably, had they not done this, these products would have remained on the market indefinitely because there were no resources to actually do these reevaluations. So they actively jump-started this process. Notably, if you look at the congressional hearings, the smaller generic companies and the farmers were adamantly opposed to this due to the fact that they thought it would lead to the removal of these generic products, which of course it did. At the codex level, we've actually also seen these innovative producers supporting these retroactive precautionary institutions, which are called the periodic review procedure. So this is just a quote from one of the annual reports in which CropLife, which is a business association for all the big innovative firms, is arguing in favor of retaining the periodic review. Notably, a lot of the developing countries and the generic producers have been adamantly opposed to this process under codex as well. So you do see the support happening just as I predicted in this theory. All right, so wrapping up here, just to briefly summarize what I've shown you so in this talk, and I encourage you to learn more by reading the book. Under these retroactive precautionary institutions, standards have become stricter on less profitable products, both nationally and internationally. These outcomes are not explained by health and safety concerns alone. And if you still have any doubts on that, I encourage you to read the book. I put a lot of effort into trying to make sure that is the case. Instead, this is driven by companies' refusal to provide information during these reviews. I've also shown that innovative firms have expressly lobbied for stricter standards on their older products because it allows them to bring in more of their patented products instead, and that these innovative firms have helped bolster and fought to retain these precautionary institutions. This has actually resulted in the precise barriers about which Argentina complained in 2007, and this example that I started off in my talk with. So I'm going to end there and turn it over to Graeme. I encourage all of you to buy the book and read it. Thank you.
Thank you so much, Rebecca. This is really fascinating, and you've done so much work. I can't believe you were able to get across so much in just 30 minutes. Very, very nice. I'm looking forward to picking the book up. And now we'll turn over to Graeme, but I want to just remind the audience that you can send your questions now for Rebecca via the Q&A function. Thanks. Over to you, Graeme.
Super. Thank you. First off, I'm super pleased to be here to provide comments on this excellent book. I had the pleasure of reading and reviewing it, which you can read in Regulation and Governance. I just want to take a few minutes to highlight a couple of things that I think are really important about the work that are beyond what Rebecca has already mentioned in her excellent talk. So the first thing that I want to say is that I think that it's helpful, this work, because if we thought about it in relation to the very well discussed three-part conceptualization offered by Luke's of the faces of power, so overt, covert, and latent, I think the book offers an analysis that reminds us that we have to pay more attention to covert power. And that it can be equally as important to understand as compared to the often more frequently examined and discussed overt forms of business power. And this is important because frequently in the work in environmental policy, scholars and comparative analysis, global governance, we speak about this concept of, in various forms, pro-regulatory coalitions, which Rebecca alluded to at the end in the discussion of the evolution of the pesticide rules in the US. And these coalitions can involve certain businesses, and sometimes they're popularly referred to as bootlegger and Baptist coalitions. And generally, from the perspective of those concerned about the strength of regulation, they're viewed positively in the sense that you see a business interest aligning with a public health, environmental stewardship interest that leads to a ratcheting up of regulatory requirements. And I think fundamentally the book is really important because it complicates this in taking note of how the private interests and also the private information that businesses have about product risks make it more difficult to ascertain whether those changes in regulation are actually in the public interest. And we can have a longer discussion about what the public interest is, and obviously there's different dimensions of that. But I think this is an important cautionary note that should inform future research in thinking about the nature of coalitions and how we think about when businesses are involved in advocating for ratcheting up of regulatory requirements, what is that doing and what are the unintended consequences that might be hard to observe because they're covert and because they're sort of hidden because of these information problems. So I think that from a sort of a larger environmental politics perspective, the book not only gives us a lot of insight into the specific challenges that private information presents, but also gives us a new way to think about regulatory design that ought to be taken very seriously. So before I turn to some questions, the last thing I want to do is I want to kind of pay tribute to a couple of other strengths that I think that the book offers. The first is that we actually it actually sort of has two empirical moves that that I think are, when I reread it in preparation for this, I hadn't really appreciated the first time I read it, so it's nice coming back to something and appreciating again in a new light. And the first is that it isn't just about strategic behavior. We get, even before the theory section, we have this really wonderful chapter that motivates why we should be thinking about information advantages. And particularly, it's the action here is that it gets us to think about how businesses have different forms of information advantage, and how a lot of previous work is focused on asymmetries around how businesses know a lot about their processes that are hard for regulators to observe. But this focuses our attention on how that similarly has implications for product risks in use, right? And that the book is more about that latter problem, which I think is really important. And to draw directly from what Rebecca writes in the book, while it may be apparent and while it is certainly well documented that firms have information advantage when it comes to monitoring their own production processes, at times less obvious and certainly less well studied is the fact that producers are also typically at a significant advantage when it comes to determining whether the end results of their process, the product, is safe and what regulatory standards ought to apply to it. So the reason that chapter is really important is it gives us a sense of the pervasiveness of this, and the dimensions of the regulatory situations that might lead to this kind of information problem. And I think that, in addition to the empirical examinations, the hypotheses that I'll turn to in a second, that alone is a really important thing to take from the book, because it shows that it's not just highly technical settings in which we see this kind of problem arising, like aeronautics, but it's also in apples, right? Things that are not necessarily highly technical, right? And that I think is a very important contribution. So the second thing, like, given that we now know that this kind of information advantage exists, the second thing that the book really does well is it seeks to understand, given this advantage exists, it takes a different empirical strategy and turns to the question of whether we can isolate and quantify the strategic behavior of firms we can expect given the presence of an information advantage. And that, I won't go into all the details, obviously, because Rebecca's already provided those. But I think that twofold strategy of giving us a sense of the pervasiveness of this information advantage, and then a very surgical examination of what we can expect firms to do, and observing that kind of behavior in these different domains, both the domestic and international level, are really amplify the significance and importance of this work. So just to close my comments before I turn to questions, so taken together, we come away with really two very deep, important things here, right? A deeper understanding of how information about product risks ought to be studied further, given there are indications that this is a pervasive problem. And it certainly opens opportunities for businesses to strategically release this information at times that serves their business interests. And second, we get a very detailed examination of the kind of strategies businesses might adopt and how we might rethink the design of precautionary regulations in situations where information advantages are likely pervasive. So again, just to sing the praises of the author, Rebecca, and the book, this is a great read, and it's a wonderful study that does incredible work empirically to back up a really insightful and important theoretical argument. So with that, I'll now turn to a couple of questions before Q&A from the audience. So I think I'm gonna can I ask two, and then you can decide. You can strategically choose which one you want to answer. The first one is a little bit of a step back and thinking, given you've done this work, I was curious, what do you envision as sort of critical next steps to further understand the meaningful variation in information advantages that firms enjoy? That's part one. The second one is a little bit more of a conceptual question vis-a-vis the sort of the engagement with the regulatory capture literature that you embed in the book. And here, I'll read it out. You've given us a very important study of the covert ways firms try to strategically use information to their advantage. And in the work on regulatory capture that you cite, there is some focus on the ways in which cognitive forms of capture can take place such that the regulator doesn't even need to be manipulated because they already have adopted the sort of the biases or the mental model, so to speak, that aligns with these business interests. And I'm curious whether if you thought about that in relation to some of the quotes and in some of the findings, to what extent do you think if you turned your attention away from the firms towards the regulators more, are they predisposed to being manipulated in this way? Are there situations where they aren't even questioning? Like you gave us some insight into that there are certain situations where they know this is going on and they want to try to prevent it. But how might we understand the regulator side of this this puzzle a little bit more? And any insights you have on that based on what you've already done would be really interesting. So I'll end there and pass it back to you, Rebecca. Thank you again.
We can go straight to you,
Great,
Rebecca.
thank you. Oh, great. Thank you so much for the kind words about the book. I really appreciate that and for these great questions. I'll take the second one first because I think this is something that did come up quite a lot. I should also start by saying I really think a lot of the capture literature is spot on. So my book is not an attempt to say that it's wrong. It's to offer another dimension of how capture occurs. I'd say in many ways this book was inspired by, as a graduate student, reading Stigler and kind of thinking, wow, these are great insights. I want to show how this happens in other ways. I do think that you're totally right that you do, and this cognitive capture that you talk about, I do think it plays out in various ways, where I think the regulators, at the EPA that I talked to, I mean, they do genuinely, I think, want to do the right thing, but they often seem to, maybe underrate the degree to which these firms are kind of behaving badly, was kind of my sense at times talking to them. At the same time, I think that a lot of why you kind of see them going along with this especially is because, as far as the regulator is concerned, they just don't want to see a scandal. They don't want a situation that's a replication of Silent Spring. And so when I actually asked them, do you guys know this is going on? And they're like, yeah, we can, here's some examples of where we've seen firms doing this. And we kind of knew that was what was going on. And I was like, well, why don't you guys step in to prevent it? And they're like, well, there have been times where, when it was totally ludicrous and they lobbied for stricter standards, we were like, no, the data doesn't support that. But if they don't provide the information, you can't make them do it. And the law says we need that information. It's like making someone pay for a gun license they don't want. That was the example they used. So I think that they're somewhat hamstrung by the rules, the regulators themselves. And I think that's partially why you see them going so much along with this, even though they know that it's not great. I still think they think it's what's in the law, and B, it's better than a scandal. So I think that's kind of what you see. As for the first question about critical next steps, I guess I'll do what a politician would do, and I'll answer it in a slightly different way, which is rather than focus on this information side of things, I would say that the research that I'm most interested in right now is actually looking at other dimensions of how regulations play out and kind of how firms and governments sometimes manipulate them in interesting and important ways. So I'll just highlight I just had a paper come out a few months ago with some co-authors that looks at this in the case of China. It shows how China has used import refusals, which is basically claims that a product that's being imported is unsafe and then refusing it at the border, strategically in order to punish governments with which it has political tensions with. So that's kind of one angle of things I'm looking at. I also have another paper that is a working paper. You can see it on my website. I'm planning to present it in a bunch of forums coming up that I'm really, really excited about because it has some really cool data, and it's a question I've been wanting to ask for a long time, which is when the EU harmonized its standards, who won? And also, why has the EU chosen to harmonize some standards and not others? And I look with a co-author with occupational exposure limits. So also a big safety question. It's how much can factory workers be exposed to chemicals in the workplace? And we just have this incredibly cool data set that has taken me about 5 years to collect. trying to understand, these political dynamics. So that's, I guess, really where my research trajectory is going. It's less the information side of things and more just on understanding different elements of regulation and specifically risk regulation.
Thank
Thank
you
you.
so much. Now we can turn to some questions from the audience, and feel free to keep those coming if you have any others. But we'll start off with one that maybe seems the obvious question to ask after this, and we actually received it in a few different formats from different people, which is assuming that resources remain limited like this for these regulators. Do you have suggestions for alternatives to retroactive precaution as a regulatory function? And would it be as simple as just requiring producers to continue to support and fund research for all products that they continue to produce? Or do you how can regulators ensure that private information is used transparently and ethically without allowing corporate interests to promise public safety? And are you aware of any other regulatory efforts in other jurisdictions where where large firms are unable to abuse the system, or innovative firms are unable to sort of rig the system like this? So that is one sort of one question that has been approached from a few different angles from our audience. And then another question is, which governments tend to put in place this type of regulation, this retroactive precaution? Is it more prominent in certain regions than others, or certain levels of development than others? And then a third question is asking whether new trade institutions like preferential trade agreements that might be more stringent than the WTO, do they make retroactive assessment of product safety harder to carry out if it's likely to impose new barriers? And if so, do you have a sense of whether and how firms' behavior might change as their countries enter such agreements? We'll start with those.
Right, these are great questions, and actually quite hard to answer in some ways. So they might seem straightforward, but they're actually pretty complicated. So the first question that came from many angles, the book is actually fairly pessimistic about the degree to which these problems are easily solvable. So, when it comes, you can't really require these firms just to provide the information, if they don't want to. You can't, as the EPA, as I quoted in response to one of Graeme's questions, as the EPA official told me, you can't make someone pay for a gun license they don't want. If a firm says, we don't want to sell this product anymore, they have no obligation to provide that information. And part of the reason why it's so hard for generics often to provide it, well, there are a lot of reasons. Part of it is they have kind of smaller R&D departments. Part of it is they were not as involved in the process of producing this in the first place, because usually the innovative producers that have the closest substitutes, they were the ones that had those original products, and they have all this information about them. So, there aren't kind of easy Band-Aid fixes for this. One of the things that I suggest that, could potentially help, well, there are a few things. So one is by kind of, to some degree, harmonizing the data requirements across countries for these reevaluations. So one problem that was expressed to me is, the EU, for example, has different requirements during these reevaluation processes than the United States. That makes it particularly expensive for firms to defend their products across different markets. So to the extent that markets kind of harmonize in what their expectations are for these reevaluations, it can make it a little bit more affordable, which could help on the margin. I suggested that when it came to these particularly useful products under Codex, and there have been suggestions that have come up under Codex of kind of how to retain those products, you could imagine having a pool of money that is kind of put forward to protect the products that are, generic but particularly useful. So, that could help at least with some of these products, keeping them on the market, where you just have a designated pool of funds. The problem is that could also create a moral hazard problem where companies say, okay, we're not going to, pay for that product because there's this pool of money. But it still might help. And these are kind of suggestions that have been put forward. There have been some others, but it's hard. And I think that there aren't really places where you don't see these information asymmetries in terms of, across countries, or where, countries have come up with the perfect solution to these problems, because it's just, it's an inherent problem. Like, these information asymmetries just mean that governments don't have the ability to do what the firms can do. So, I mean, I guess I would say I encourage any of you who are interested in this, that this could be, if any of you are writing or thinking about a dissertation topic, or, graduate students, this is something maybe you could think about is, what are ways that governments can address information asymmetries, and kind of how, maybe you can find some examples where governments have been more or less effective at doing this. I kind of talk about it more in terms of, what are the different bad outcomes that you get? And, maybe we can think about which are the least bad outcomes that we want, but not a place where it's been totally solved. In terms of which countries implement these institutions, it's pretty much where you might expect. It's the same sorts of countries that have other types of precautionary institutions. So it's, the richer countries that tend to care more about safety. Certainly under Codex, you see time and again that the developed countries that can afford the more expensive products are the ones that are arguing in favor of these institutions, because they help prevent, as I say, I mentioned the talk, it's partially orthogonal to safety, right? So it's not that this is 100% bad. It is also potentially preventing a second silent spring. And that's why it's really important to control for those characteristics of the pesticides. But it's also, leading to these products being more expensive unnecessarily. So, you do see developed countries more likely to impose these sorts of regulations. On the preferential trade agreements, can this make these sorts of behaviors harder to carry out, and does this eliminate retroactive precaution? Short answer is no. The reason is that, I guess there has been some pushback in some cases against precaution. So you can think of the GMO case. Genetically modified organisms, this is a different type of precaution. So the EU historically has been very opposed to genetically modified organisms. They've said, we don't have enough information to know that these things are safe. And so we're basically going to try and ban them to kind of ensure that, since we don't know, that we don't get something really dangerous. And there was, a lot of pushback from the United States. There was a WTO, trade suit filed about those GMOs. And so, you can get a pushback where, it's being said there isn't science backing this position, and sometimes that works. But when it comes to this retroactive precaution, since the Codex itself, which is the relevant international standard setting body, is imposing these institutions, and it itself is eliminating these products for a lack of information, even if you have a trade agreement, you still have the international standard that is doing the exact same things. And that's kind of part of the problem that I really try and highlight in the book, is that, this isn't just a domestic issue. So it's not just that, you can tell countries stop doing this and then that will solve the problem. These international standard setters are doing it just as much as the domestic governments are doing it. And so that kind of complicates, you just putting a trade agreement saying, oh, you can't do this, because you're already doing it at the international level too.
Thank you very much. That was very interesting. I hope the audience members are satisfied with those answers to their questions. We'll end with just two more, I think, because we don't have that much time left. So the first one asks, or first starts with a bit of information. The EU has put in place new regulation to empower consumers for the green transition. This means that before buying a product, consumers will receive better and more harmonized information on its durability and reparability. In addition, vague environmental claims will be forbidden, meaning that companies will no longer be able to declare that they are green or environmentally friendly if they cannot demonstrate that they are. And it will also be forbidden to display unreliable voluntary sustainability logos. Do you think that these types of regulations address the information asymmetries sufficiently, or do they not really force companies to be more transparent? And second, the new incoming US president has been portrayed as being in favor of deregulation, but your argument is partly that companies do not always want deregulation because of this competitive advantage. Do you expect that there will be a corporate opposition to the deregulation agenda? Over to you.
Two great questions. The second one I've actually been thinking about a lot recently. I was just talking to a friend about it last night. But let me start with the first before I forget it. So I think that addresses a different type, I would say, of information asymmetry. It's the information asymmetry between the consumer and the producer. That's a type of asymmetry that's been talked a lot more about, I would say, in the literature. And so, I'm sure it helps. These things help, but they can also be misleading. For example, there are these companies that say, we don't have any genetically modified organisms in our products. And that seems like, okay, that's good information. You're providing that to consumers. It helps them make better informed choices. But it also is potentially misleading, because some GMOs you might think are bad and some are pretty harmless. And so then it makes it seem like all GMOs are bad when you say we are GMO free. So you could argue that, that's providing information, but it's not necessarily providing, helpful information. It actually ends up being misleading. So, whether or not those, I think it's entirely possible that that's going to be helpful. I think often providing more information to the consumer is good, but it's kind of addressing a different type of information asymmetry. And, I guess the jury's still out on I think firms always have ways of kind of manipulating what information is and is not provided in ways that suits their interests. So I don't know. I guess I'm pretty pessimistic about how these things play out, but maybe it'll probably be better than nothing. On this deregulation thing, yes. So, Trump in his last term was very much in favor of deregulating the car industry, the fuel emission requirements. And actually, the bunch of the people in the car industry were like, no, please stop. We don't want you to do this. So I think you'll probably see in some areas something similar. The reason the car industry didn't want some of those deregulations that Trump was trying to put in place is the car industry doesn't just sell to the US, they also sell to Europe, and Europe has pretty strict standards. So this actually ties back to some work by one of my colleagues now, he's emeritus, David Vogel, who's talked about the California effect and why it is that you actually sometimes get a ratcheting up of regulations rather than a ratcheting down. I think there are certain industries that will very much want deregulation. I'm sure the oil and gas industry will be thrilled. But my hope, I guess this is kind of what I've been telling myself is a silver lining of Trump's reelection here, is that, a lot of the regulations that have already been put in place, they become sticky once they're in place. You start to get interests that benefit from them and push to retain them. So my hope is that some of the stuff he wants to deregulate, even if he does, the companies are going to keep, adhering to the higher regulations because they're selling to other markets that have those higher regulations. So fingers crossed. But, to put, I guess, end on a bright note, maybe we'll see that.
Thank you so much. That is unfortunately all the time we have today. I do have a couple more questions from the audience, but I think I'll just pass those to you via email if that's okay, Rebecca, in case you're interested. And sorry that we couldn't get to all the questions. I would like to once again thank our guests, Rebecca Perlman and Graeme Auld, for joining us today for this excellent discussion and a very interesting book. Before leaving you, I'd also like to announce that our next webinar on December 18th will bring in Professor Cornelia Wohl to discuss her book, Corporate Crime and Punishment, The Politics of Negotiated Justice in Global Markets, quite relevant with today's theme. In addition, we have just begun to announce our 2025 lineup, so you can check out eurenew.eu. For those, we're going to bring in Anita Godis, Sungjun Cho, and Hilka Dijkstra next year. So please take a look at eu-renew.eu to sign up for those. Thanks very much for joining us today, Rebecca and Graeme, and all of you in the audience, and see you next time.
Thank you very much.